Hello, and welcome to the symplr Education Series webcast. Today's webcast is titled Understanding Negligence in Credentialing with speaker Kathy Matska. At the end of the session, we will have time for a formal Q&A, and feel free to ask any questions as they come to mind via the chat box located on the right side of your screen. You'll also be able to download the archive of today's webcast presentation and slides later at www.symplr.com, and we will send this to you in an email as well. This continuing education certified webcast is sponsored by symplr, along with Cactus Software and HC Preau. We're so pleased to have Kathy as our speaker this month. Kathy's a consultant, speaker, writer specializing in provider credentialing and can help hospitals, long-term care facilities, physician practices, and more with her experience. I'm sure many of you know her already, but I'd like to turn the presentation over to her now.
All right. Well, thank you very much. Okay, so we're going to talk about understanding negligence in credentialing today, and I first have to give my little speech that I'm not an attorney, and what I'm doing here is sharing some of my experiences having participated as an expert witness in almost 50 negligent credentialing claims over the last 5 or 6 years. So what I want to do is give you an idea of what you can expect, what is looked at during these negligent credentialing lawsuits. Now, each state does things differently, so I'm going to be speaking in general terms as we go through this. So first of all, why are credentialing and privileging important? Well, there's a number of reasons why they're important, and of course patient protection is the number one reason. If you look at the mission or vision statement of most healthcare organizations, you're probably going to find some kind of language that refers to something like providing high-quality patient care to the residents of our community. Well, this high-quality patient care can only be accomplished by the facility and the medical staff reviewing and only allowing those providers who meet those minimum qualifications to provide that care. We also have our risk management issues, liability considerations that have to be considered, and these are very important as well. If the patient suffers an adverse outcome, the facility can be held liable, and if the practitioner has some kind of quality of care issue that would have been revealed by credentialing, but credentialing wasn't performed appropriately, then the facility may be found separately liable for that patient harm that's caused by that clinician. And this is kind of where the negligent credentialing language comes in. Another reason that healthcare organizations credential is because it's required by the accrediting bodies, the Joint Commission, CMS, DNV require it, state hospital licensing regulations require it. If we're not meeting those regulations, the organization may risk losing its accreditation status or licensure or Medicare certification. So it's really important that we do credentialing. So just a general definition of negligence. Negligence is defined as conduct that's culpable, meaning you can be held responsible for it because it falls short of what a reasonable person, or in the case of a hospital or healthcare, or reasonable hospital or healthcare organization, would do to protect an individual from a foreseeable risk of harm. So if the organization knew or should have known that a practitioner is not qualified or not competent, and then that practitioner injures a patient through an act of negligence, the organization can be found separately liable for negligently credentialing that practitioner. Healthcare organizations have responsibilities under a number of different theories, and some states have actually accepted the tort of negligent credentialing. I believe there's at least 30 states that recognize a claim of negligent credentialing. But there are also some other theories under which healthcare organizations can also be found liable. And in some states, that negligent credentialing piece would fall under like the corporate liability or corporate negligence doctrine. And the premise of this theory is that a patient who comes to the hospital does so with a reasonable expectation that the hospital is going to attempt to cure him and keep that person safe. So the hospital has a duty to make a reasonable effort to monitor and oversee the care and treatment that's going to be prescribed and administered by those physicians that are practicing on the property. So, and a hospital's responsibility also includes giving privileges only to competent practitioners. The governing body is given authority to make final decisions in all credentialing matters, and this is spelled out by the CMS regs, by accreditation standards, by regulatory requirement, other regulatory requirements, state regulatory requirements. So the governing body is the ultimate authority, and the board can delegate an activity such as overseeing those people that have independent privileges on the medical staff. The governing body does maintain the ultimate responsibility for all those decisions that are made. Another term, respondeat superior, is a common law doctrine that makes the employer liable for the actions of an employee when those actions are occurring or taking place within the scope of that employment. So the doctrine is often applied to contracted or employed practitioners, and you know we see a lot of employed practitioners nowadays. I saw a statistic just recently that said that over 50% of physicians that are getting out of a training program now are going into employment, the type of an employment with a healthcare organization. So we're seeing more and more employed practitioners. And speaking at different conferences, 10 years ago, if I would have asked how many of you employ practitioners, I probably would have seen 2 or 3 hands come up. Nowadays, everybody's hand goes up. Everybody's employing practitioners nowadays. We also have a theory called apparent or ostensible agency, and this is a legal doctrine that's used to hold someone liable for the acts of another person, a third party, because that third party looks like or appears to be an agent of that person or organization. And this theory is frequently applied to facility-based providers such as anesthesiologists, emergency physicians, pathologists. The basis of this theory is that the patient really has no choice in choosing these practitioners, so they're kind of felt to be an agent of the hospital. For example, when you go into the emergency room, you don't get to pick which emergency room doctor you see. When you have a radiologist that reads your x-ray, you don't get to pick which radiologist is doing that. So even though these people might be independent contractors and not employees of the organization, there may be an allegation that there is an apparent or ostensible agency because they appear to be an agent of that facility. Now, some elements of negligence, and again, each state kind of words this a little bit differently, but usually it's very similar to this, but there may be a little bit different language in your state. But just the fact that someone didn't credential someone adequately, that in itself doesn't mean that the organization was negligent. For example, say that a hospital fails to verify a medical license for a qualified and competent practitioner within the prescribed requirements of accreditation standards. This in itself is not negligence. Excuse me for just a moment, please. Apologize for that. We just got a severe thunderstorm warning and my alarm went off. Okay, so where was I? Okay, so just because an organization fails to verify a license does not necessarily mean that that's negligence. There has to be some specific elements present in order to establish negligence. There has to be a duty to exercise due care, and then that duty has to be breached. Then there has to be an injury to the patient, and the breach of duty you did or did not do has to be the reason or the proximate cause of that injury. Finally, the person who's bringing the charges has to establish that the injury resulted in compensable damage. Now, there's an easy way to remember this, and it's called the 4 Ds. The deviation from duty directly causes the damages. So looking at our example that I gave earlier about the physician injured the patient and you didn't verify the license. So if the physician injures a patient and it was found that this injury was a result of negligence on the physician's behalf, if it was found that the organization failed to verify the license on initial appointment, and if it had done so, it would have found that the license was suspended, well, then it can be reasonably assumed that had the organization credentialed the physician appropriately, it would not have granted the physician privileges. So in this case, it's pretty easy to connect the dots and see that the breach of the hospital's duty to appropriately credential the physician, it could have resulted in that injury to the patient ultimately. Okay, so let's look at each of those areas. So the duty to exercise due care is defined in a number of ways within a healthcare organization. We have state licensing regulations that might have requirements for adopting criteria and for granting medical staff appointment and privileges. Accreditation standards might specify what type of primary source verification has to be completed and specify the specific requirements for credentialing and privileging, policies and procedures that have to be made available. Your medical staff bylaws, or your facility bylaws, rules and regulations and policies, they may include additional requirements above and beyond the regulations and accreditation standards. So if you have a requirement that goes above and beyond, so for example, you may have a requirement at your facility that all practitioners are board certified or obtain that certification within a couple of years. So if that's the case, then you're going to be held to that requirement. So finally, there's case law in individual states. When things occur, then this case law further defines things within that state. So examples of breach of duty. In many cases in which organizations are found to be negligent in their credentialing practices, the facility has all the appropriate bylaws, policies, and procedures, but it fails to consistently apply those requirements. So this really emphasizes the importance of knowing the requirement of your facility's bylaws, rules and regulations and policies, and making sure that you're following those. Another potential for breach of duty is the failure to address any kind of concerns that were identified in the credentialing or recredentialing process. So documentation in the credentials file should address all the issues or concerns that are identified when you're credentialing or recredentialing someone. For example, if a verification letter comes back and there's a response on it that's different than the information that was provided on the application, so maybe different affiliation dates or different staff status or so forth, then there should be documentation in the credentials file about how you resolved that issue. So in addition, your medical staff and governing body minutes should document how these bodies addressed any concerns that were identified. So for example, suppose you're recredentialing an applicant and you find that this applicant was named in a number of medical malpractice lawsuits since their last application. Well, your medical staff reviews this and they see that none of these cases have been settled, they haven't been to trial, and they've gotten information that from the practitioner, they've reviewed them. So they feel that there's really no reason not to grant medical staff appointment based upon these outstanding cases. Well, if that's the case, then there should be some documentation that the issue was addressed, discussed, and what the medical staff opinion was and the basis for that opinion. And finally, if you adopt a credentialing policy or procedure or privileging criteria that don't reflect what a reasonable hospital would do, this can also be considered a breach of duty. For example, most hospitals verify past medical staff appointment for initial applicants. They may do everything from medical school forward, they may do 5 years, they may do 10 years, but most hospitals do verify medical staff appointments, either all of them or they set a time frame and just go back so far. This verification of hospital affiliations isn't required by Joint Commission accreditation standards, but it's it's something that most hospitals do. So the fact that it's something most hospitals do, it means it's the standard of care that all hospitals that are Joint Commission accredited hospitals are going to be held to. So it's essential that your policies and procedures meet the requirements of your organization's accreditation standards, as well as any kind of state or federal regulations that may address those issues as well. And if you see that there's a difference in accreditation standards and what your state or federal requirements are, then you need to, the good rule of thumb is to follow the strictest requirement that's set. A precedent-setting case is one that establishes a new legal principle. So what happens then is that the principle is based upon the court. It comes to a conclusion based upon the facts in the case, and then that finding in that case is then after that considered authoritative, meaning it's going to be followed from that point on when the court is presented with similar or identical facts. So that way they don't have to keep making this up each time or doing a finding each time. They'll then refer back to those cases, and that's when I mentioned case law earlier. So let's take a look at a couple of these precedent-setting cases. Darling versus Charleston Community Memorial Hospital is a 1965 case, and it's really the very first case in which a hospital was found to be negligent in allowing a doctor to practice at the hospital. Before this time, hospitals were looked upon as charitable organizations, and there was something called the charitable immunity doctrine that said that they could only be sued up to the limit of their medical malpractice or their professional liability insurance, and they weren't required to even have professional liability insurance. So if they didn't have any, they basically couldn't be sued at all. So this case, this Darling case, set aside that doctrine. Darling, a little bit of history about it. He was a football player. He broke his leg during the game, and he had his leg placed into a cast by the on-call doctor. Afterwards, he got gangrene and ended up having to have his leg amputated below the knee. And plaintiff claimed, and the court agreed, that the hospital was negligent for a couple of reasons. Number one, it failed to properly review the work of that independent doctor. There was also an issue about its nurses not administering appropriate tests. So in this case, Darling said that the hospital bylaws and licensing requirements and the standards, the hospital accreditation standards, were evidence to establish the standard of care that hospital should be following. And the jury did agree with them and said that the hospital had breached its duty to act as a reasonably careful hospital. So this was the very first negligent credentialing claim that we had. There was another one that goes back a ways, Johnson versus Misericordia Hospital, which is a 1991 case. This was a case in which the hospital was found liable by a patient who was injured by a physician who didn't disclose information on his application. Doctor was doing a surgical procedure, and he was trying to remove a pin fragment from the patient's hip, and during the surgery he damaged the common femoral nerve and artery and caused permanent paralysis to the patient's leg and weakness and loss of function. But the patient settled this claim against the doctor for the medical malpractice and then went after the hospital, alleging the hospital was negligent in appointing the doctor to its medical staff and in granting him the orthopedic surgery privileges. When the doctor completed his application, he stated that his privileges at other hospitals had never been suspended, diminished, revoked, or not renewed, and you know that question that you see on all those applications. And he also failed to answer any of the questions pertaining to his malpractice insurance, and so the hospital didn't verify the information on the application, and if they'd done so, they would have found that he had denial or restriction of privileges. And some of the hospitals that he even listed on his application, he hadn't even been granted privileges. And one of the CEOs at the hospitals, one of the hospitals that he listed, testified that they couldn't even find a documentation that he'd even requested privileges or an application. So that information was readily available to the hospital, and if the hospital had credentialed the doctor appropriately, it would have found that these hospitals had a concern regarding his competency. And if they would have, the hospital would have verified his medical malpractice information, they would have found out that he had 7 medical malpractice suits that had been filed against him just prior to his initial appointment. So these were, you know, a case in which if the court found that if the hospital had exercised ordinary care, it wouldn't have appointed this physician to the medical staff. So looking back, there is case history that shows that we really need to be doing this credentialing. And if you look at most states now, you will find similar findings in most states in the United States. Another thing that we have to make sure of is that when we're providing information, that we're giving correct information, because you know, we want to make sure that what we're providing is correct, and that we're not omitting key information as well when we're answering these verification requests. One way that this can, you know, omitting key information can be avoided is by keeping all your information in the credentials file, or having a cross-reference in that credentials file if you have information in another place. If there's you need to make sure that whoever's answering those verification requests has access to all the information they need in order to do so. I know of a case in which a medical services professional provided information to another hospital, answering a verification letter, said that the physician had resigned their appointment and temporary privileges in lieu of being terminated. But unknown to that medical services professional, the hospital had worked out a written agreement with that physician that said that the hospital was going to reply to any verification letters with a statement that the physician had resigned in good standing. Well, unfortunately, this information didn't make it into the credentials file. It was kept in a separate file in the legal department. So when the medical services professional researched medical staff minutes and looked back to try to find out what happened with this physician, she only found reference to a recommendation for termination. So that's what she put on the letter that she received, the verification. So the physician then didn't get appointed at this other hospital based upon this information that was provided, and then sued the hospital that provided the information for providing wrong information. So you want to make sure that you're not omitting, that you're providing correct information, but you also want to make sure that you're not omitting key information when you're answering. The case of Catholic Medical Center versus Lakeview Anesthesia Associates is a great example of what can go wrong, what can happen when wrong information is provided or when pertinent information is omitted. This letter that you see on your screen is actually a letter that was provided to Dr. Lee Berry when he was terminated by his group. He was fired by Lakeview Anesthesia Associates for working in an impaired condition. So this is a blown up copy of that section of the letter that states that Dr. Berry was being terminated with cause due to having reported to work in an impaired physical, mental, and emotional state that prevented him from properly performing duties and puts their patients at risk. So this letter was sent to him, as you can see on this date, March 27th of 2001. Well, after Dr. Berry was terminated by Lakeview Anesthesia Associates, he started working as a locum tenens physician, which we do see some locum tenens physicians that have some baggage in different places. Not all of them, of course, but you do tend to see that. Eventually, this locum tenens work landed him at Catholic Medical Center in Richland, Washington. Now, Catholic Medical Center had credentialed Dr. Berry, but the letters they received, they didn't disclose his impairments. Then if you see the people who signed these names that are circled here, you see Dr. Mark Dennis and Dr. William Preau. Well, here's an actual copy of Dr. Dennis's letter. You know, he says, I've worked closely with Dr. Berry for the past 4 years, an excellent clinician, pleasant personality. I'm sure he's going to be an asset to your anesthesia service. The letter from, and note the dates, this is June of 2001, just a couple months after they terminated him in March. So Dr. Preau writes, this is a letter of recommendation for Dr. Lee Berry, worked with him at Lakeview Regional Medical Center for 4 years, excellent anesthesiologist, capable in all fields of anesthesia, including OB, peds, cardiovascular, all regional blocks. I recommend him highly. So the Catholic Medical Center had also written to Lakeview Medical Center to confirm Dr. Berry's appointment there, and they got back one of those letters that just gave the dates on staff and said there was no disciplinary action and contact us if you need additional information. So they did not supply any information about Dr. Berry being terminated. So he had one of those contractual issues where, you know, if you're part of a contract and you're no longer a party to the contract, then your medical staff appointment automatically terminates. And as well, I believe at the time of when he got the termination, it was around the time of his recredentialing, and they just kind of let it run out. So the hospital didn't take any action on him at all. The doctors who did provide this information, though, certainly left things out. Dr. Berry was granted privileges at Catholic Medical Center, and there was a patient who was just delivered her third child, and she decided she wanted to have a tubal ligation done. And the doctor said, well, hey, let's do it while you're here rather than bringing you back. So took her to the OR, day after her baby's born, and does this tubal ligation, and Dr. Berry is the anesthesiologist, and he pulls her breathing tube too early, and she suffered a heart attack and some massive brain damage. And this resulted in a multi-million-dollar lawsuit against Catholic Hospital. But during the course of that discovery, the letters that you've seen here were provided to plaintiff on order of the court. So Catholic first learned that Dr. Berry had been terminated by his group during the discovery for the case. So Catholic says, well, they should have given us information. So they turn around and sue Lakeview Anesthesia Associates and Lakeview Medical Center for failing to disclose Dr. Berry's impairments. And initially, the hospital won its case against both Lakeview and they sued also Dr. Berry. So they won against Berry and Lakeview Anesthesia Associates and Lakeview Hospital. But then the appeals court then reversed the decision against Lakeview Medical Center because they found that the reference letters from Dr. Berry's former employers were false and they were patently misleading, but the court felt like the Lakeview Medical Center's letter was not materially misleading. They really didn't lie, and they did provide information that was truthful in that the letter. They also found that Lakeview didn't have a legal duty to disclose its own investigation of Dr. Berry or its knowledge of his drug problem. So they reversed the judgment against Lakeview Medical Center. So what can we do to decrease the chance? There's a number of things that we can do. I can't tell you that you're going to, by doing these things, you're never going to have a finding of negligent or a lawsuit for negligent credentialing, because I think that eventually this is something that every hospital is going to have to face. But what we can do is some tips to help decrease the chance of a finding of negligence in your credentialing practices. And so the first thing is training for medical services professionals and medical staff leaders. It's really important that medical services professionals are involved in their state and local NAMS chapters, attending those conferences for the National Association of Medical Staff Services and the state associations. It's a good idea to get people training so that they know their job, and attending these programs is really a good way of doing that. Medical staff and leaders also need to have appropriate training and know what they're getting themselves into when they say yes to taking on a job as a department chair, a credentials committee member, or a member of the medical executive committee. And they need to be trained in their responsibilities and in how to review those qualifications of their peers. This can be something as simple as sitting down with department chairman and going over how to read a credentials file and how to respond to issues, or something more complicated and of course more costly, like bringing someone into the hospital to train your medical staff leaders, or sending those medical staff leaders to educational programs where they can get good training about their roles and responsibilities in credentialing and privileging. Another thing that's really important is to have the medical staff involved in all phases of credentialing and privileging. It's really essential that your medical staff leaders review all the information that's in the credentials file, that they're not just trusting the medical services professional to do a good job, that they're actually reading those verification letters that come in, they're actually looking at the data that's received, comparing the procedures that someone is doing at other facilities to the privileges that they want to do at your facility, making sure that you have all the information that they need in order to make a reasoned decision regarding the competency of those providers. So it's really important that they're reviewing those credentials files. Also, making sure that you're following all of your policies, your procedures, your bylaws. And many times bylaws and procedures will mirror language that's contained in accreditation standards. So over time, accreditation standards change, and so we change our practices to reflect the new accreditation standards, but sometimes we neglect to make appropriate changes in our bylaws and policies to reflect those changes, which might result in a failure to follow our own policies. An example of that is, over the last few years, many hospitals have gone away from what's called a provisional period of appointment and gone instead to the Joint Commission and HFAP language of doing a focused professional practice evaluation. And they developed FPPE and OPPE, ongoing professional practice evaluation policies and procedures. So when they develop these new policies, they may do these focused evaluation in a different way than they did with the provisional appointment. But if you still have language in your bylaws that calls for a provisional appointment and spells out some specifics regarding that, you still need to make sure you're following that as well. So make sure that you're following all those policies, procedures, and bylaws that you have. It's a good idea to audit your bylaws and your rules and regulations and policies. And when I go into a hospital as a consultant, that's one of the, before I ever get there, that's the first thing that I do. I say, send me a copy of your bylaws, your medical staff rules and regulations, and any credentialing policy and procedures that you have. And then I look through those and read them and make sure that they comply with the state regulations and accreditation standards. And then when I go to the facility, I ask them, are you doing all this? Or if I ask them how they're doing, if they're doing something and it's different than what their bylaws or policies say, then I'll say, well, this is what your policies say, or this is what your bylaws say. So if you find that in practice you're doing something that's not in compliance with your bylaws or your policies, determining the reason why you have that. Why is that in your bylaws? If it's not required by a corporate policy or accreditation or regulatory requirements, then talk to your legal counsel about changing those, whether or not you should change those bylaws to reflect your current practice. Now, a good example of this is the one that I gave earlier. Many hospitals have a requirement for all physicians to be board certified or actively participating in that board certification process. And this isn't required by state or federal regulations or accreditation standards. I think there's one state maybe that does require board certification as a condition of licensure. But if your hospital has such a bylaws requirement for board certification, it needs to follow that and apply it. If you find that you're making exceptions to those rules, then it might be time to consider changing that requirement. When it comes to the credentialing and ensuring that only qualified, competent practitioners, the first line of defense is a really thorough credentialing and privileging process. I want to kind of close with a couple statements and a survey some survey results. The American College of Physician Executives, they do a big survey every year, and in 2006 they did a survey on patient trust and safety. There were hundreds of questions on there, and they asked the same questions to patients as they did to physicians, but this was one that really stood out to me. Is there a doctor in your community that you would avoid because you think he or she makes medical mistakes? Patient responses, 20% of patients said yes, 78% said no, and 2% really didn't have a clue. But look at the difference when it comes to physician responses. 77% of the physicians that were surveyed said there was a doctor that in their community that they would avoid because they felt that this doctor made medical mistakes. Pretty significant numbers, if you ask me. A more recent study, the Mongan Institute for Health Policy at Massachusetts General Hospital did a study in 2010, and this was a study on whether or not practitioners should report impaired colleagues or incompetent colleagues. And out of the physicians surveyed, only 64% agreed that physicians should report impaired or incompetent colleagues. And out of those that surveyed, 17% had direct personal knowledge of an impaired colleague. 17%. So, but out of those 17%, only 67% of them actually reported that impaired colleague. And the reasons that they gave for not reporting were, one, they felt that someone else was taking care of the problem. They thought if they reported it, that nothing's going to happen anyway. And then some of them said that they had a fear of retribution. So they felt like if they reported that something might come back on them. And I can see if you're relying on consultation and referrals for your patients, that if you report someone might think that, hold that against you and may not refer patients to you anymore. So these are all issues that affect physicians nowadays. So it was kind of a sad ending comment to this survey. It said our findings cast serious doubt on the ability of medicine to self-regulate with regard to impaired or incompetent physicians. So this is something that really medical staff members have to do. They have to step up and take charge when it comes to impaired or incompetent colleagues. In summary, negligence is conduct that is culpable because it falls short of what a reasonable person would do to protect another individual from a foreseeable risk of harm. And healthcare organizations, hospitals, even managed care organizations, and ambulatory care facilities, critical access hospitals, all of them can be found separately liable for negligent credentialing of practitioners. And a thorough credentialing and privileging process that is consistently applied is very important for all facilities to have. Okay, I think we're time for a commercial break.
Thanks so much, Kathy. That was a really wonderful presentation.
Thank you.
Going to pause for a brief. You're welcome. Now we're going to pause for a brief commercial break and talk about symplr as it relates to this topic. symplr Provider Privileging has the most comprehensive and only customizable privileging database kept current by our team of expert researchers. It has a living database of privileges, on-demand data access, and granted privilege lookup. If this sounds like something that would benefit your facility, please contact us at sales@symplr.com. That's sales@symplr.com. So now please join us for a Q&A with Kathy. If you haven't done so already, you can ask your questions in the chat box that's on the right side of your screen, and we'll get to as many as we can. I'd also like to remind everybody that the slides for this presentation will be available afterwards. A few of y'all have already asked about that. We'll email you a link to the slides and the presentation itself, and then it's also available at www.symplr.com. So Kathy, first question for you. What is your recommendation regarding the provisional period since we do the FPPE and OPPE?
Well, I think that it's provisional period of appointment is something that has probably seen its days, and now it's time to move on to some new language. If you're not using it, many hospitals, when these FPPE came out, they kind of just incorporated it into what they call their provisional period of appointment. If that's what you're doing, then there's no reason to change that language. If you are actually, some facilities actually have what they call a provisional category. So when somebody initially gets appointed to the medical staff, they're appointed to a staff category called provisional staff. If that's the case, I think that language is probably old language that is not really valid anymore. I mean, it's okay if you do it, but it's not contemporary language that we see in bylaws anymore. Usually what we can use some language that says that initial appointments to the medical staff are for a provisional period. And the reason that we see that in there is because that is old Joint Commission standard language. Back in the old days, the Joint Commission standard specifically said that all initial grants of privileges are for a provisional period, and initially it said for at least a year. And then they changed it to are subject to a provisional period, and then they took the whole standard and moved it into just an explanation that said if the hospital uses a provisional period of appointment, it's documented in the bylaws. So basically, by moving that there, they kind of did away with the requirement that you had a provisional period of appointment. And then we went full circle back again, and we got new language about focused professional practice evaluation. So now we're back pretty much with the same thing we had before with provisional appointment being mandatory provisional appointment. Now we are calling it FPPE. So basically, I mean, it's kind of semantics. You're doing the same thing. But so what you need to do is look at what do your bylaws say. Are your bylaws defining a provisional staff category, or are they just including language that says initial grants of privileges are for a provisional period? And if that's what they say, the provisional period, that's okay to keep that in there. But I mean, it doesn't make any sense to have both that and the FPPE, Focused Professional Practice Evaluation language. If you're going to do with FPPE, I would just go with the FPPE, and that way you don't have the confusion like what's provisional, what's FPPE. You have just one policy that covers it.
Great. On to the next question. Do you have any advice for new CMOs educating new department chairmen for reviewing initial appointment files?
Well, there are some excellent courses out there. Greeley has some good ones. The Horty Springer has a nice one. So there are some formal education. The American College of Physician Executives puts on some nice educational programs for medical staff leadership. But when it comes to just reviewing credentials files, I think what's important is that the people who are working in credentialing, the medical services professionals, need to just sit down with those department chairs, credentials committee chairs, MEC members, and just go through a credentials file and say, here's what the credentials file looks like, here's how it's organized, here's what you need to read, all of these verification letters that come in, and you need to compare the data that we're getting from other organizations to what they're doing now. They need to understand that when it comes to a negligent credentialing claim, those people who sign off on those privileges will probably be deposed in that case. And the person who is going to be deposing them is going to ask them, what is your process? What do you review? How do you determine that this person is competent and qualified? So they need to know, number one, what kind of information is being collected, and what to look for as far as red flags and so forth. And also they need to understand that if they're not comfortable with what's in that credentials file, that they can ask for more information. If they don't see, if all you're getting back, for example, is letters, somebody's requesting privileges, you have a general surgeon who's coming to you from another facility that is, another hospital, and all you're getting from those hospitals is a letter that says, due to the volume of requests that we receive, we're responding with this form letter, and he was on date from this date to this date, and there was no disciplinary action. There's nothing in that letter that says that somebody is currently competent to do the things that they want to do. So your medical staff leaders need to understand that they can say, this isn't enough. How do I know by just looking at this that this person is competent and qualified? So they can ask for additional information. If the provider doesn't want, if you can't get it from the hospital, then you need to figure out, if all you're getting is the due to volume of requests that we receive letter, then it's time for you to get the practitioner who's applying and involved and have them sign a consent release form authorizing that hospital to provide that information to you. It's just really important that they know what's in the credentials file, that they have the authority to ask for more information, and that they're going to be held responsible for those decisions that they're making.
Great. On to the next question. Please describe how the National Practitioner Data Bank should be used in credentialing process. Can it be considered a primary source?
The National Practitioner Data Bank is not a primary source. All the National Practitioner Data Bank is a depository of items that were, licensure disciplinary actions, or they are medical malpractice cases that were resulted in a settlement where that on behalf of that practitioner, or issues where a hospital takes an adverse action, or medical society or so forth takes an adverse action against a provider based upon quality of care issues that lasted longer than 30 days. So there are some managed care managed care standards that with URAC, NCQA, so forth, that do allow you to use the data bank as a for final judgments and settlements for medical malpractice history. But as far as verifying licensure sanctions, if you're going to, it's not considered by the hospital accreditors as a primary source for verifying those elements. It is a requirement that you verify that you do query the National Practitioner Data Bank, and it's because the Healthcare Quality Improvement Act of 1986 requires that you do that. So you have to query because of the Healthcare Quality Improvement Act, but that information from a hospital standpoint is not considered a primary source.
Great. Next question, what is required to verify education? Must you contact med schools as primary verification?
No, and I don't. Contacting the medical school is probably the least. It is a mechanism you can use, but it's probably the least desirable. You can use the Student Clearinghouse. You can use an AMA profile. An AMA profile is a good tool. You have to pay for the service, but the AMA profile you can use to verify education there, as long as it's a ACGME approved medical school, it'll be on there, and ACGME approved training programs are on the AMA profile. So you can use the AMA profile to do that. Probably the easiest way of doing it. You don't have to write directly to the school. That takes a long time to get those back, and you're better off just doing an AMA profile or using the National Student Clearinghouse if they report to them.
Okay, looks like we have time for a couple more questions. The next one is a quality report required at reappointment? Since we do OPPE, it seems unnecessary to have quality at reappointment.
Okay, well that depends on what your policies and procedures say. If your policies and procedures say that you're going to do a quality profile, then of course you need to do it. I remember when OPPE first came out, I attended a Joint Commission seminar on it, and the speaker there, I asked that specific question. We generate these reappointment profiles that have all this information on them at recredentialing. Now that we're doing OPPE, can we stop generating those reappointment profiles? And she said, yes, you do not have to do that anymore. What has to be done, though, is when your department chair, your credentials committee, whoever it is that's making that first recommendation, signing off on those privileges and that recredentialing, they need to take into account all the OPPE that was performed over the last 2 years that person's been working. So for example, you're recredentialing a provider, and your medical staff is department chair is going to be reviewing and signing off on it, then they should have with them that OPP data that was reviewed. So it doesn't have to be put into some kind of a quality profile or anything like that. They can just have the data available, be able to look at it and refer to it when they're making that recommendation. So those recredentialing quality profiles, if you're doing OPPE, those have kind of gone by the wayside. We do see people who who do report demographic information, like if you have a requirement for attending a certain number of meetings, that you would include that on there, or if you have other medical staff requirements, that people that are not related to quality, that need to be, that your bylaws say are going to be evaluated at recredentialing, that you might have to pull those things together. But the quality profiles, you don't have to do those, you just do it based upon OPPE. Doesn't make any sense to recreate all that stuff.
Great. Next question. What do you think about aging policy that mandates your older providers to get a physical exam to check for any impairment?
I don't think that's a bad idea, and I don't think it's just to check for physical impairments. I think also cognitive impairments I think it's a good idea to have it. There's some difference of opinion regarding this, of course. There's some people that, especially aging physicians, that do not agree with this type of a thing. But if your bylaws, it's your medical staff's policy. Your medical staff determines it. If you want to be on the medical staff, when you get to a certain age, most of the policies that I see are 75 or somewhere around there. If you get to a certain age, then what they may say is that we're going to either do, you may go to an annual appointment after that date, or you may have to have a statement from your primary care doctor that they've done a physical and cognitive exams, and that you are physically and mentally able to perform those privileges, the functions that you want to do at the facility. I think it's a good idea.
Great. Another question. Why doesn't the NCQA require or accept fellowship verification for training? If a cardiologist is applying to an MCO, his fellowship is pretty important, isn't it?
Well, I don't know that it's not that they don't require fellowship training. What they require is that you verify the highest level of training, but fellowship doesn't count. What they're saying there is that you have to verify at a minimum residency. So and there was an FAQ on their website. I don't know if it's still there or not, but it did address this, and it said that fellowships there are formal fellowships, there are informal fellowships. Some people will complete a residency training and then do what they call an informal fellowship with a place. They may go work at a hospital or work with a physician group that they're doing what they call a mini fellowship or something like that, and it won't be an ACGME approved training program. So in order to make that, so they make that cutoff at residency. So it's not that they don't require, they expect you to verify relevant information, of course, but what I think the standard actually reads that that fellowship doesn't count as verifying the highest level of education. The idea is that if you complete a residency and it's an ACGME approved residency, you can't get into that training program without having done the medical school. So they're saying then that you don't have to verify the medical school if you verify the residency, I think is the way it works. I'm not exactly positive on the actual wording, but I know you only have to verify the highest level on that, but they don't count fellowship because there's too many informal fellowships.
Okay, last question. What is the process if AMA reports a training as being verified? It can't be used as a verification?
If they report it as verified, it is able to be used as a verification. If they report it as not verified, then you cannot use it. So what happens sometimes is there's a lag time between somebody gets out of their residency training program, you have a new resident that's coming to you in July. You're doing an AMA profile on them in June because you want to have them ready to go in July, but you find that they do have it reported that they're participating in the training program, but it says not verified. That's because they haven't completed the program yet. Usually there may also be some cases where you don't see them very often anymore, where a training program that was done many years ago might say not verified, and it may be that that training program closed and they don't have any records or so forth. So if it says not verified, then you're supposed to find some other way of verifying it. My first my first inclination would be to contact the AMA and ask them why specifically that one is not verified, and if it's because it's closed or something, you can ask them if there's, if they have any idea of any other way of verifying it, or you can just document your discussion with them that program was closed.
Fantastic. I believe that's all the time we have for today. Kathy, is there anything you'd like to say in closing to our audience?
No, thank you so much for allowing me to speak with you. And if you have any, if you have any questions afterwards, you can feel free to send me an email, kathymatska@kathymatska.com.
Thank you so much, Kathy, and thank you to HC Preau for partnering with us on this event today. A recording of this webcast will be archived at symplr.com, and we'll email you a link as well, along with the PowerPoint slides. For those of you who are receiving NAMS CE credits for this, we will also email that to you as soon as those are made available to us. If you have any questions for symplr, please contact us at communications@symplr.com. Thank you so much, and we'll see you next time. Bye.